Thanks, Riley. Good evening, everyone. My name's Matthew Joins. As Dan rightly introduced me, I'm the CEO of Wikipad and Gamevice. There's an interesting point was novelty. When we look at patents, I look at it, I'm a lawyer myself, and this is a very vexing area of expense, time, and problems. And I'll go on to some patent trolls that we dealt with later on. But a partner in my business is a gentleman called Brendan Uribe. Some of you may know him. I don't know if you do. He's the CEO of Oculus. And his partner is John McCormack. And John takes a very different view on patents. And John says, don't patent anything. So that's one approach. He has a very open source approach to it. And I spoke to Brendan only about 2 weeks ago, and as you know, he just sold his company to Facebook. It's the fastest startup to 2.3 billion ever. Fortunately, he's a founder in my business, so that's kind of helpful. And I said to him, we were talking about patents. He said, we're not filing any. We're not doing that at all. And I suppose when you've got a big bucket partner like Facebook behind you, you can take that approach. But I said, surely you'd made some patent applications prior to this moment. He said, no. He said, John, it's absolutely against it and wouldn't join the company if we applied for a patent. So I said to him, how do you value a company without patents? Because this is obviously a very important issue to whether you make an application for a patent or you don't. Is there an economic return on it? And I will go into, we took a totally different approach. We spent very heavily on patents. And Brendan said, look, I've just sold the company 2.5 billion, they didn't care. You do the math here, Matt. And I said, fair enough. It's difficult to understand the difference between value to a strategic acquirer over a value of a patent. And what Facebook bought in Oculus is they bought a community, they bought a very experienced software team. They didn't buy into a protective patent because they were going to build a community. So I think you have to look at what your business is, what its goals are, whether you need a patent or not, because they can be very expensive. So, sorry, Dan, I've just done that job here somewhere. Anyway, I just want to show you.
I do want to add one piece to that.
Yeah.
Google is the second largest patent application company, right behind IBM.
Yes, they've got deep pockets too. Anyway, I'm just going to show you our product. It's a really simple piece of plastic, basically. You know, you put it around a tablet, and you can start to play games with it. And that's an MFI. You've just seen it before Apple announced it, by the way. So yeah, you just slot it in here. So you can see we needed patents to protect us. So we took a totally different approach. And then you can go console game on the mobile, you can cloud stream PC games now to an Apple iPad. I think they're announcing it next week, so you get an inside ahead on that one. So we filed a lot of patents. We spent about $700,000 on patents. Fortunately, Dan was very generous with us, and as a startup, he took a view. And he took some of that money in stock, which was great, and helped us greatly. So, you know, there were ways of skinning the cat. We were very, very fortunate to have Dan. We managed to get our patents in record time. I was absolutely astonished how quick, in under a year. Apple have one, and this is the prior art. They have controllers at the bottom of the tablet and the smartphone, and we have one to the right and left. So it can be just a simple difference like that can get you your patent. We're filed all around the world, China, I think all across Europe. And I do think it's made a difference on our value proposition. It was, as you know, it's very difficult raising startup capital. You know, I had to use my own, which is not so hot, and friends, and you know, all the things that you're going through. It became easier once we had the patents in place, because I think, you know, people felt more confident that we had a protectable business, which is obvious in a way. And money started to move towards us, which became a self-fulfilling, virtuous cycle. The more money you have, the easier it is to move forward. And eventually, you know, we became an authorized Apple manufacturer in China, which is a big step from 2 years ago when we were in the same situation you and Apple have been a terrific partner, but patents certainly played an important part, and this is something that Apple told us. They said, look, go make this for the Apple iPad, we will police your patents. And I'm like, oh, that's great. So they said, we can stop the distributors distributing it. We just pick up the phone and say, okay, there's an infringing one, but we want this one. So you can find that your supply chain, in our cases or in hardware, can really help protect your patent portfolio for you in surprising ways. And I think patents do help a bit. We've had a couple of knockoffs in France. We have one that copied the WikiPad completely. I mean, just utterly, they contacted us, they signed a confidentiality agreement with us, they wanted to be a distributor, and the next minute they made a knockoff copycat. And the problem with France, of course, is it costs a lot of money to sue in France, and they're protected by the French government, who just has its own rules. So even with a patent, there's not a lot we could do about that. We were a small company, so we actually took a view on not to sue them. I really want to sue them. I mean, it's just flagrant. So much for a patent. It was just an absolute flagrant. The other flip side of the coin is that China respects, the bigger companies. So when somebody like Apple says, "I respect your patent," they kind of fall into line, and that's what's happening in China. The other problem of patents is patent trolls. We've been sued by a patent troll. That was just outrageous. Just some company in, of course, it would be Texas, sued us. Google, Apple, Microsoft, just about everyone you can think of. And it was a completely bogus claim, utterly bogus. But then you look at once you receive the claim, you can't raise any money because people will be put off saying, "Have you been sued for any patent infringement?" And you go, "Yes, I have. I've just been sued by this horrible little troll in Texas at some little county court who knows his uncle's brother who's the mayor of this, that, and the other. Has already been paid off, probably." And it just stalls the business. So we went into panic mode. I thought, my God, they're going to really shake us down for a lot of money. But really, all they wanted to do was shake us down for 10 grand for their legal time. So we ended up, thanks to Dan, we just settled quickly. I mean, we didn't infringe their patents at all, and we paid them $7.5 grand just to go away. So patents can also cause you problems from people just using the legal system to attack your business plan, and there's not a lot you can do about it. From a businessman's point of view, I think you have to look, as Dan started his part of this talk, look at carefully what your business is, whether it's needed at all in the business, and it's a big investment in terms of time and cash, and there are some hard fees in it which you have to keep paying. Issue fee, $7 grand, a renewal fee, $4 grand. So for us, we have basically about 3 patents. We really have spent an awful lot of money keeping them going. It's a question of that.
So saying all that, do you still think it's worth it for you, or to have a patent for all your?
Yeah, I think for us in the hardware space, of course, I think it was a critical, essential part. But I think if you have momentum and you have a clever software team, and like Oculus, they didn't. And Oculus is a hardware play. It took exactly the opposite approach, and it's already sold for $2.5 billion. I've still a long way to catch up to Brendan on our competition. I think you have to look at your own business. I don't think there's not an exact answer for yes or no, but it is very costly. I think it's not online in the Bible. Work out how much it costs before you start on your journey. Another question.
Hey, this is about infringement and how to possibly prevent it. So, I have a friend of mine who's a general counsel of a fairly significant company, and told me that in order to prove patent infringement, you have to prove that the person willfully violated your patent. And so, as a general piece of advice, it told me never read anyone's patent. Is there some truth to that, or what are your thoughts on that?
I'm sorry, say that again, please.
So as a protection against being sued for patent infringement,
Never do what?
Never read anyone
somebody
else's
else's patent for willful infringement.
Oh. What? Read all the patents you want. Willful infringement really deals with once you have received actual notice. In fact, the issuing of a patent serves as notice to everyone in the world. So whether you read it or not, if it's issued, you're already on notice. Matt's example where you entered a non-disclosure agreement and he shared all of his technology with the lads from France, and they copied it, that would certainly qualify for willful infringement. So willful infringement really has to have some elements that it's not just that you read the patent. You actually would have had to gain more information and target that particular company. Now,
I would have said they were definitely willfully infringing, but there's a pragmatism to business. You know, I'm a barrister in England, so I'm a trial lawyer there, and I did done a few injunctions in my time. And you know, you just even going to the court in England for a passing off claim can cost you $50,000 to $100,000. That's like $170,000. And then when you sue, can you enforce? Can you even get those monies back? So the patent becomes a kind of an empty tiger. And that goes back to your question whether it's worth doing. You've got to take it to the next step to think, if you're going to enforce it, it's going to cost you a lot more money. There's a question here.
It's kind of related to what you just said. Is it true that if you don't enforce your patent, it becomes less enforceable? Like if you let somebody infringe on your patent, your patent becomes less defensible?
that is not correct. Now, it is true if we're talking about trademarks. There's a requirement in trademarks that you must police your mark, which means that you have to go after people that are using your trademark, or you stand an opportunity to lose your rights in trademark. But patents, no. You're not required to enforce your patents. You can choose to do that or not. If someone is infringing, as Matt said, he's mad as hell at these guys, but said, number one, they don't have any money. It's always a good rule of thumb, if someone doesn't have money, don't sue them. Wait until they get to the point where there's actually some money to be had. It is difficult for small companies to enforce their patents, but if it's blatant, you're always going to be able to find attorneys that will take it on a contingency case. So,
in England, that's so. Go ahead.
Matt, you had said that you feel like it was essential that you had your patent had filed for patents and whatnot. Do you feel it was essential because of the actual hardware that you were patenting, or because of the investors, feeling more comfortable with that you had a patented product?
Yeah, no, that's a really good question, because did I do it in order to raise money, or did I do it for a good business reason? And the truth is, I probably did it to raise money. I mean, it's not the right decision to make. Okay, I should have gone through the thought process and said, but I think I would have always come to the same decision, particularly for this. I'm not so sure, with the other businesses I'm involved with. I think I have changed my views on patents, and I've been much more wary about them, whether they're useful. I kind of, now listening to Brendan and John a lot, kind of get where they're coming from, that by not publishing a patent, nobody knows what they're doing. They keep and know how to show how they keep innovating, they keep investing, they've got a top-end software team, and they just keep changing, so nobody can keep up with them. And I think that comes out of having the capital as well. So for us, there were definite milestones. Without the patent, I think we wouldn't. I think Dan has built the value in the business to as much as a patent can. Ours is a very clear and obvious kind of patentable device. And I would say the latest round was at 125. I would say that the agreements with Apple were key to that 125 million. And I don't think we would have got there without the patent. So yes, you could trace it all straight back. But having said that, I mean, we do have very strong distribution agreements in place all around the world, and the distributors will enforce your IP for you if you have a close relationship with them, because they won't stock another SKU that's similar to yours. You just tell them to stop it. Or give them more margin, one or the other.
Yeah, I think, you know, from the business side, you have to take a look at what is the market that you're approaching. And you know, Matt and his team did a phenomenal job on scoping, you know, the rest of the market and where it's going and what was going with gaming, and upcoming future products on this is going to continually increase its usefulness in the market. So he identified the market and he identified a need, and the thing was going to be exploding. So one of the things you want to do is, put it this way, patents can be thought of as locks on doors. It will not necessarily deter a thief that really wants to break in. He's going to break through your door. But people that aren't in the mindset of being a thief are going to say, oh, the door's locked. So it helps preserve, you know, from a business, your competitive advantage. And as Matt said, I guess Matt and Mark are my sons. If you get into a situation where you have distribution, they're very interested in the market share that they're going to have. And if they see that they have an advantage utilizing your product with their product, they don't want to lose market share to someone else that's coming in with copycat infringement. So I mean, they have a tremendous amount of motivation to protect their revenue stream, and part of doing that.
That's a very good point. Sorry to butt in, cross over there. Distributors of whatever, if you have a hardware product, it's different, most of you probably in software, but the hardware product line is a race to the bottom because everything gets commoditized, and that is a problem, and that's why investors do not like hardware plays. I mean, at the moment, there's a bit of a shift in investor communities on Series A, Series B, Cs towards hardware. I don't know, you know, because of the connectivity between the ecosystem changing slightly because of the cloud. But the distributor, if he has 5 products that all look similar, the race to the bottom means they get no margin, and it's good for the consumer, but it's not very good for the retailer, and they just have just a big overhead. So they definitely are wanting to choose a category. The euphemism is category leader. You've heard that many times, I'm sure. And what a category leader is somebody who they have an interest in protecting their market position by promoting them over and above other ones where their margin may be less, and not crowding the market too much. They want to give consumer choice, but at the end of the day, they don't want so much choice that they have no margin. So that's another benefit to having a patent. It definitely can propel you to being a category leader. In our case, of course, we're not a category leader per se, but it's definitely a new vertical, and that helps a lot and gives us the opportunity to become a category leader in gaming accessories. But yeah, I think the distributors can be your friends.
Got a question, yeah.
Yes.
A practical example. Let's say now it's 2009, and I make a drawing of your product, and I send an email to my sister or whatever. Now, 2012, you filed a patent. You did, no? When did you file?
I think we filed in 2012.
12. And then you get patent. Now, can I come to you and say, I already thought about it. Here's the proof. I sent an email in 2009. This is a drawing. I was going to do it. I just didn't patent. Is that valid? I mean, can I do our case?
Well,
Because the
under the law, there must be a published document, or there could be an actual hard product. But you know, a lot of problems can go into, well, I made this sketch, I made this drawing, so it's my product. It was never published and not available for anyone else to know. Pretty much now everywhere in the world, it's first to patent for many years, dating back to old Thomas Jefferson. We were first to invent.
That's what I maybe as referring to.
first to invent system. Today, through global harmonization of intellectual property, we're the first to file. And the only things, keep in mind, you have to have full disclosure on how it's going to work. You know, what are all the components? What are, in his case, what is the software, how's it interplay with the hardware, and things like that. So that all has to be laid out. And if you have just a sketch and you sent a letter to your sister, including a sketch, that wouldn't count as publication number one, and it's highly unlikely.
But what if it was published?
Okay, if it was published and it disclosed everything in the claim,
Sure.
and your publication met all the requirements of the statute, that would be a valid prior art. Any published document is valid prior art.
Sure, okay, that's clear.
So even if it's a PhD thesis in Russia, and it's published by being placed in a library, one library in one university, that counts.
Okay. So it is in a way first to invent, as long as it's published.
That can serve as a block to obtaining a patent. It can also serve as a block to enforcing the patent.
Or to get some royalties.
Any piece of prior art that would preclude you from getting a patent, if it's out there, it also precludes you from enforcing the patent because that would render the patent invalid.
But if I wrote that piece and in 2009 and it was published, can I sue him and get royalties or some kind of? Could I?
No.
Because it was published, so I can't report it.
Did you get a patent?
No, but it was published.
You have no grounds for the suit. You can only sue for infringement based on an issued patent.
You raise an interesting point. If you did, in our case, and I could find someone that went back and they were sensible, and I found them having some prior art, say 20 years ago, it's in my interest to go and do a commercial deal with you, because it would set any challenge even further back. So you would probably find a
I
commercial
see
deal
what,
with
because then I could start doing the same thing and you couldn't stop me.
Oh, no, it's not that you couldn't stop. If you're already off and running, say you have a business that's up and running, it's making some revenue, and you really wanted to even more enhance your patent portfolio by saying, oh, well, I've just taken a license from you or given you a royalty stream for 20 years beforehand, that would only improve my position, because somebody else would have to be 22 years. Do you see what I'm saying? So you could probably do a commercial arrangement, I'm pretty sure. I would. I would just be practical about it. I wouldn't bother. He's saying that.
And he wanted to settle for a lot more money with patrol.
That's true. So, very true. Well, we've got a lot of questions for some sort of stuff there. Do you want the microphone out there?
I just have a question. Let's say you had a hardware software solution.
Okay?
How specific do you have to be on the software description? Do you need like code snippets? Do you need, how specific do you have to be?
Basically block diagrams. When you're doing a hardware-software combination, you can actually cross a boundary that normally can't be crossed, and it's called claiming functionality. In the electronics part of the business, think about taking a pile of components. There's a pile, and you put 10 engineers in 10 different rooms, give them all the same components. Each one of them is going to come out with a different circuit. So the only way you can really address that situation is by talking about the functionality being delivered.
That's what you might block.
But you don't need to include code. I've never included a single line of code in any patent application.
But we filed some software patents.
I'm sorry?
But we filed. How did you do we filed a software patent for the wall, so that might be helpful.
Yeah, we have it's called a work widget. It's kind of a very interesting little product. It's a piece of software that is a virtually rotatable icon cube. And you can take it, you just spin it, and each face, how many faces you want, it's up to you. Each one of those spaces can have a link into any application or to a movie or whatever you choose to put in it. And we did get a patent for that, but it's a computer that has the software that enables people to take their finger and just spin this thing around, opens up, does all sorts of things. So, again, a piece of software is useless unless it's residing on hardware. So we actually went up for a hardware patent that incorporates that software.
Thank you.
Yeah, I just wanted to ask, okay, your opinion of Amazon's one-click patent and whether or not it would get passed today, the more stringent Supreme Court decision. Did you hear that, Dan?
Yeah, it's the one click.
A lot of people thought it was very obvious.
Well, obvious doesn't mean what it means. Obvious is a term of art in patent law. Gee, that sounds like a reasonable thing to have done. I don't know why I wouldn't have done it. The test is, has it been disclosed in prior publications? Now, if I remember correctly, their patent on a single click has that software embedded in some sort of computing device. Right, so it takes a general purpose computer and turns it into a specialized computer that can do a particular function. So I think if no one had really come up with a single click, they could probably still get that patent.
Yeah, a question about how you manage the prototyping, user testing, iteration process, and how you protect that. Like if you file a provisional patent for an invention for mixing claims, and then you take it on the road and test it, and it's altered in those tests, how do you manage that?
You're actually asking a question about reduction to practice. And in patent law, you do have the right to go out and test your product. And so if you can show continued diligence in pursuing your invention, it dates back to the date of the invention, which means you guys need to start really good logs and write stuff down and how you proceed. If you're going through and doing testing on the product itself, as long as you have your first date of invention, that's all included in reduction to practice. Now, the other side of that coin is be cautious on where you're doing that. How are you testing it? How much are you disclosing? And how much do you keep secret? Now, Oculus, there were very few patents that I did when I ran $1 billion chunk of Seagate, because I had a development team that we continually move forward and do just evolutionary steps in the disk drive. When I first started in the disk drive industry, the disk was 3 foot in diameter and the rewrite head was the size of a pack of Camel cigarettes. And they used hydraulics to move it back and forth over the disk. Today, you get a disk drive smaller than a wristwatch. So, making certain that companies need to be market driven. And what you want to do is put yourself in a position where you have the best value product out there. You're providing the best quality, you're providing the best performance for the dollar. And you're continuing to go through evolution of making certain that your market is always put yourself in that position. What is the term you use? Category leader?
Yeah, the investors are you saying stuff like having a monopolistic patent is definitely one that gets them excited. What's your unfair advantage? Have you got a monopolistic patent? You know the rules. I'm sure.
But
I think one quick is a good example. Can you step through what would be the logic by which a company decides, especially when it's software, whether or not to pursue a
Okay, yeah, I don't know if everyone here understands what design patent is. Design patent is for the look, the look of the product itself. What are its artistic features, if you will. And so you're protecting what the aesthetic projection of the product. The utility patent protects the idea and the device itself. Software, always keep in mind that software falls under the category of copyrights. The majority of Microsoft's intellectual property resides in copyrights. How do you acquire ownership in different intellectual property? Copyrights attach as soon as you put your thought or your expression in a tangible form of medium. A quick example, you write a letter to your sister. Mail it, she receives the letter, she owns the letter, but he still owns the copyright. As soon as he is done with the work, he automatically gets a copyright. Now, registration of the copyright gives you some legal capabilities that are not afforded a person that doesn't have registration. Trademarks. Trademarks automatically come into existence when you use the mark and associating it with a good or service. So it has to be used in commerce. Okay? Now, once you have a trademark, then you go through registration of the trademark, and that puts in another whole layer of legal protections for you. Patents are upon the issuance after examination. So copyrights are automatic as soon as you're done with the work. Trademarks, as soon as you apply it and associate it with a product or service. Patents, when you go through examination. Getting a copyright on software does require you to go in and get certain pieces of it. And there is a certain number of sheets that are required to be filed with the Library of Commerce to get a registered copyright. So there's no rules on how big the font is, and no rules on can you use double spacing. And so when I do copyrights on software, I assure you I never allow core. What's the real key piece of the software? That never shows up in the document. You may get 4 lines on a piece of paper, and you'll get the number of papers they ask for. So I mean, there are ways to protect that. Hopefully that answered your question.
Right over here. We're going to come around this way.
So, how safe is provisional application? If someone else filed patent when the provisional application has already been done, so it is safe and it's safe to disclose, show it to anyone else when you have provisional application?
Let me see if I understood the question correctly.
So how
How safe
safe?
is the patent during prosecution?
Provisional application.
Go ahead.
Provisional application, provisional.
Provisional application can never be enforced. It's never examined. It's a placeholder. Now, provisional application can be a benefit if you're out there and you're trying to work with people and you're going to enter. They don't always work. You're going to enter non-disclosure agreements. Right? If a person sees that you're pursuing a patent, if they're on the honest side of mindset, you're probably going to be okay. Once you have the provisional patent application, if you do share the intricate details of your patent, your product, and then you continue on with the process to get the utility patent are successful, you don't have any issues. In fact, if you've given a provisional patent application to someone and you continue through again, you can only enforce an issued patent. But that is incredibly good evidence in court if they do infringe, that was absolute willful infringement. And if we could get our French company to sell some product in the U.S., we would have fun.
Yeah, they're quite smart not to do that. I think there was a question.
Next question.
Did I answer your question?
Yeah.
Okay, yes.
My question is about the design patent that you were talking about. So, for example, if you're a small company starting up, let's say we're talking about sketches, especially like in fashion. So you have certain artwork that you want to protect. But if you're a small company, just because you published it on a product, would that ensure you some protection, or would it be preferable to go ahead and then register that artwork, either as copyright or design patent?
If you're a small company and you have sketches, the least expensive thing to do is register copyrights, and it's not that difficult. Oftentimes, I will teach a young entrepreneur. I'll file a copyright and have him work with me to see how it's done. Once you see how it's done, you guys can file your own copyrights. It costs you like $35 a time, maybe 40 now. So copyright is a very good thing. It doesn't protect the idea, but if you're looking at design sketches, it helps protect. The difference between copyright of design, it protects you against their copying that piece of work. Now, if you do a number of renderings of multiple views of a thing, and you're thinking in your mind, we're eventually want to get a design patent for this, very few attorneys think about derivative works. Derivative works can actually be pretty powerful, and that, I'll give you an example in my head, is an architect did a phenomenal job on home, and somebody actually, and we had copyright protection on his design, somebody built a house, and all they did was a mirror image. That's it. They just flip the paper over, and now we're going to build a house that way. And we nailed him for the house being a derivative work of his drawings. And we're successful in that case. So I don't discount copyrights, provided that you have enough views that a derivative work can actually be a product. Typically, a copyright, for example, of a photo. If you have a Nancy Lavins photo, and you decide you're going to go to exactly the same spot that he was in, exactly the same time of year, the weather's identical, you take a photo that is not an infringement of his copyrighted photo. That's your interpretation of what you've seen. So if you want to do that, you can. There's nothing to prevent that. If you get one of his prints, go to the copy machine and start printing them out, that's copyright infringement.
Going to your photograph example, I just read an article recently about the national parks not allowing people to publish photographs that they take in those national parks. Do you know anything about that?
Sounds like it'd be fun for me.
Yeah, it was an interesting article.
Yeah, it's the national parks can suggest non-publication of photos. That's about it. They cannot preclude you from publishing your works.
I have another question about
Yes.
software.
Okay?
I'm wondering what it is exactly that can be protected under copyright, especially if the code is written in an open source language. I don't think it's the code itself, but I'm wondering if it's the whole application, because it's probably the combination of all of it. But would you say the code itself is also protected?
Yeah, the entire work is what's protectable.
Right, so it's the combination.
It's
of
a combination. There's, it's getting more difficult to see anybody doing absolutely true original software. You know, I would caution you on take a hard look at what the requirements are when you're using open source code for building your particular application. So take a look and see what the requirements are. Sometimes you're going to find yourself in a position that they'll have ownership to a royalty stream if you're not watching it. So go ahead.
Just around question about the $700,000 spent. Can you on the 3 patents? Can you just break down how much of that was like creating the patents versus spending so far?
I don't know where he came up with that. I think he was pulled it out of somewhere. Somewhere it was in there.
It is unfortunately took a view on it. But no, how much was, you know, it's let's say we're
getting close to that.
If we're going to apply for a utility and a design patent in the US, from making the application, assuming I'm not a patent lawyer and I can't write it all down, all the way through to prosecution, it's getting challenged a couple of times by the examiner. How much would that cost? And they do Google's patents.
Do you off the top of your head know how many applications and patents we have out there?
We have a lot. I think that's that much.
Around the world, we have close to 225 applications, and we're starting to get issuance on those. So it's pursuing patents. I use the term non-US patents can be very, very expensive. They decide that they like to give annuity fees even before they start doing the examinations. So they come knocking on the door for money at a continual basis. Now, I can just tell you that I've structured my rates as flat fees, and I compare them against the competition nationally and well below what they are. So I'm very competitive on that side. And how my structure is for a provisional patent application, I charge $4,500 plus $150 per drawing page. Now, if you continue on with the utility application, and I don't write all the claims, the most difficult thing to do is to get the claim set right that eventually gets the patent. Quick statistics, about 55% of patent applications that are filed actually ever get issued. And in fact, saying it's crucial that you understand the novelty when you're pursuing a patent and make certain you get that wrapped up. And Matthew is correct, and I'll even tell you this, there can be a lot of fighting back and forth with the patent office. The best way of looking at this is when you file a patent application, you are bringing a lawsuit against the federal government to receive your rights to your property. And you file it, and the patent office will take a look, and just like when you file a civil suit, you're going to get an answer. And then it's referred to as an office action. And they're going to lay out legal reasons why you should not be awarded a patent. I've had 2 patent applications that the first thing I got was a notice of allowance. Other than that, it averages at least 3 rounds of argument. So they give you an office action, you give all the legal and technical arguments back of why they are not correct. They'll come back and oftentimes will say, you know, you're right with the prior art that I showed you, but in light of the new prior art I'm giving you, here's a new rejection. So it's, you know, it can be a very long process. My success rate is well over 98% in getting patents that issue. And it just goes back to making certain that you have knowledge. Each one of those times that we're doing the legal arguments, it's $3,500 per office action. Once you've gone through office action sequence, and the examiner still says it's a final rejection, you can take it on appeal. And that's before a panel of 3 federal judges that you argue the appeal. For drafting the appeal brief and taking it to appeal, I charge $6,000 for that. Over the last, I want to say about 8 years, between my partner and I, we've argued over 70% of electronics appeals have been before court. He lost 1 claim. I've not lost. So there are avenues to go. Now, something that's happened recently is I went through the process, I won the appeal, and this happens to be on a business method patent type scenario, which is they're trying very hard to kill that. And I found some path that we could follow. I won the appeal, and the director of the PTO reopened the case, and he assigned 5 senior examiners on it, open the case and argue again. I had to go through that process again. It's now back on appeal. I'm pretty certain I'll win that appeal too. I hope the director will do that. So when all is said and done, we've got probably the utility patent would be 9,500 plus the 150 per page. If you do the provisional patent, what I do is when it comes now time to do the utility, I charge the 5. The 5 represents the most difficult part of the work. The other part's time. Doing the claims can take a very long time. You want to come up with as few limitations as you possibly can. The more you say, the more you give away. So the maximum amount of property that you can get is gotten by the fewest number of words used. So you kind of keep that in mind. So probably at least 3 office actions. So you're looking at maybe 20,000. He had our first patent we got through was pretty unusual. I got it with only one office action response. But again, I think his product, we were able to capture the amount. It's not unusual to spend 30 grand on a patent, and once you get it, then you get to pay maintenance fees. So it's still pretty true. The price of a Buick is about the same price as the patent over its life. You want to buy a Buick, you want to get a patent.
You touched business model patent. Can we still do it? Can you patent the business model?
If you're clever. Yeah, it's very difficult to do. You really have to take a look at having an effect of whatever you're doing kind of has to have a change in the setting of the environment that you're working in. What we're trying to patent is a method for government to collect revenue that's not taxation.
Okay. So it is possible, I guess.
It is still possible. It's very, very, very difficult. And the office doesn't like it. It's against their internal policy, and that's pretty indicative when the director decided that he just wasn't going to open that can. Like I said, wait till it's done, but I think I found the avenue to be able to do that. Go ahead.
I have a question in a slightly different direction. If I'm writing a book and I interview a famous doctor and I record the interview, who owns the intellectual property of that recording? Do I own it, or does the doctor own it?
Is it, you brought the tape recorder with you and you're recording it?
I brought the tape recorder and I would tell him I'm recording it because I'm researching a book. Is that recording my intellectual property, or does he have a stake in it?
That's a really good question. You own the tape itself. if the tape were going to be a work in and of itself, so now we're going to sell the tape and people get, put it on a disc and they're going to listen to it while they drive back and forth to work. So that's a work in itself. He's the one that created that work.
He created it. Even though it was an interview, and I came up with the questions. It's a curveball.
Yeah, it's a really good question. You're the one that you're phrasing the questions. You are actually crafting what the contours of this work is going to be.
Right. And he's giving me his knowledge. He's the subject matter expert.
It's okay, as long as what you are doing the creative piece and deciding which are the pertinent questions to ask. And so you're actually forming the contours of what comes out in that tape. So you are the owner of the intellectual property. My suspicions are he is not giving a lot of creativity as opposed to giving known responses. You said he's a doctor, so.
Like he may be the only person in the world who, he might be telling me, let's say he was involved in the Ebola crisis, and I'm interviewing him about it, and he has personal accounts of what happened.
Okay.
So, but I'm leading the question, but he is telling me things only he knows.
Okay.
Who's the owner?
Still, he is not. Pardon?
I make a few films as well for my students. So yeah, no, I did this with the Greenpeace thing. He would be definitely has a right to his own life story, and you just get a release from him, and then you could publish it. You would need to get that from him.
Sometimes it's not possible.
He's dead.
Well, if you're taking on, let's take it to the next step. I said if this tape were being used and actually being sold, we're now, in essence, it's his performance that you're selling.
Yeah, so you need his life.
Then you need his assignment. But now, if you're doing the interview and you have it on tape, and now you're taking that and putting it in your book, right? That's your expression in the book. So if you're writing a book, that's still your intellectual property, even though your research, came from this individual, and you're just, if I were you, I would give an attribution in the book. We're very so grateful to Dr. Jones.
In the back?
Yes.
Wouldn't the distinction on that be the amount of whether it's a creative work or not? It's just information, like any news report has been interviewing people, not necessarily copyrighted, but when it's made tangible in creativity, that's copyrighted.
Well, the one that's writing the article is always the author, and copyright is a very low threshold.
Well, like mere information, like that's not copyrightable, I don't think. Like
phone books are copyrighted. In fact, Feist phone book is a famous case on how low the threshold is on copyrights. It's really low.
Everyone, we have to wrap up. It's almost 9 o'clock. As you probably read on the board, you're going to start preparations for President Obama's visit here on Thursday.
We were the warm-up act.
So thank you very much for doing the warm-up act, Dan and Matt. I hope everyone got bits and pieces to put the story together. It is a very complicated and diverse subject about intellectual property. So this is a starting conversation. I think for those of you who are well versed in it and have experience in it, you may have gotten different things from it, and hopefully for those who don't have any experience in it, you've also gained something as far as how to approach intellectual property. I don't think you want to lose sight of that we talked about provisional patents which have 1 year on them for you to do something. As Dan said, that is a good stepping stone if you're starting a business. But as he pointed out, you can't do anything until you actually have a patent issued, and that trademarks are much more flexible for you. So for all the startups, I think those are the things to think about as you evolve. As we know, not many startups have $500,000 or $750,000 to invest in what they're doing, but you still need to protect what you're doing. So there are those mechanisms, and I think Dan and Matt have illuminated that very well. So I want to thank everyone for coming tonight, and keep your eyes posted about how Thursday goes here across campus. Thank you.